गौरव जी, आप कुछ कहना पसंद करेंगे?
नहीं सर, आई जस्ट वेट इफ देयर इज एनीथिंग ही आस्क्स.
अच्छा, मैं सोच रहा था कौन करेगा ओपनिंग बैटिंग आज।
Subject to correction, I think you always did in college.
डेजा वू।
Other hearing matters.
Your Lordship's thesis, my lords.
Yes.
So I'm grateful for the accommodation by the bench to hear us today. I'm appearing for Mr. Parshuram, who is for some of the private respondents, my lords, in the matters. And by way of my rejoinder submissions, my lords, I will focus on the issue regarding these 32 posts that have detained, my lords, your lordships, in this matter. On the question of the fast track courts, my lords, I have sought to cover the aspect in my initial submission, so I will not be repeating that, as the judgment of the division bench of our court, my lords, in my respectful submission sufficiently covers that question. Now, my lords, on these 32 posts, please for a moment have a look at the memo that was filed by the High Court before the division bench, my lords, when the matter was being heard. What page is it? It's separately in your lordship's file.
8999 ಇದೆ ನೋಡಿ.
Dated 8/9/2025.
Yes.
My lords, now this memo had first surfaced, my lords, in the course of the hearing, and there was no pleading as such as regards these 32 posts at any stage, my lords, be it in the writ petition or in the appeal or by way of any amendment to the pleadings. I don't intend to be technical about it, my lords, but only to say that in a matter of this sort, where the assertion is that a seniority list ought to be redone, it would be incumbent, my lords, on the petitioners to plead and show how there has been any prejudice in the matter. But keeping that submission aside, if your lordships have a look at the memo makes two or three things quite apparent. One is, my lords, that in respect of each of these posts, there is a notification of the state government, my lords, that comes to be issued. That is column number 2. Then, my lords, in the last column, which is the explanation bar remarks of the High Court on the administrative side, several of these indicate, my lords, that the posts, though originally created for a time-bound period, have gone on to become permanent. And as such, my lords, the post of the district judges stands increased in the cadre strength. This is quite important because these posts, my lords, having become permanent, resulting in a cadre strength, and owing their genesis to a notification of the state government, would fully meet, my lords, any requirements, be it under Article 233 or the rules framed, my lords, by the state with respect to the district judges holding their offices. And your lordships can take it from me, the explanation in respect of these duly mentions the increase in the cadre strength and the situations where, my lords, these have come to become permanent. Now, here your lordships may see the language of Article 233. I have earlier submitted, my lords, for your lordships' consideration, that Chapter 6, Article 233 onwards, basis, my lords, the law laid down by the Supreme Court in, my lords, Bal Mukund Shah and others, is a complete code in itself. The requirement of Article 233, if your lordships have a glance, 233(1), appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to the state. So at the highest, what 233 contemplates, my lords, is consultation between the High Court and the governor. The use of the word governor in 233, my lords, indicates essentially an executive function by the state and not legislative. It is indeed the case, my lords, that in various states, including the state of Karnataka, there are rules framed by the state, my lords, in exercise of powers under 309. But as far as 233 is concerned, such rules per se are not contemplated. And on the facts of this case, I'm very respectfully submitting, my lords, that the consultation requirement is fully met. The rules do not restrict the cadre only to permanent posts, as I had sought to argue earlier. The cadre strength is the total number of posts, and I will take your lordships to that rule once again. The state government has been involved at various levels. The state has issued the notification. The posts have become permanent in due course in several cases. And the fact that the High Court has treated the cadre strength as having been increased is not only not opposed, but in fact, my lords, may I say, consented to or even ratified by the state in the course of the hearing before your lordships. The state represented by the learned additional AG has been on the record, I'm instructed, my lords, to submit my lords, that the state has no objection to this course of action that has taken place. Now, that being the case, my lords, the question of reopening the seniority list on the basis of these 32 posts, simply because they were sought to be classified as temporary at some point, with great respect, my lords, not only exceeds the remit of the original petition, but really tantamounts to a roving inquiry not warranted on these facts, because it does not really, my lords, show prejudice on the part of the original writ petitioners. In fact, an increase in cadre strength inures to the benefit of all. And one of the main reasons that has weighed with the learned judge who differed and felt, my lords, that the state governments once over must issue a notification formally increasing the cadre strength was the fact that there could be some cost or expenditure element as far as the state is concerned. Now, that may be a bona fide requirement, not in ordinary service jurisprudence. But when it comes to appointment and promotions of district judges, especially on the facts of this case, where the initial notification is on the record, 233 requires consultation by the executive branch, and the state is on the record, my lords, stating fairly that no further process or formality of issuance of rules is required, then, my lords, I think the matter would rest at that. And here, if your lordships just have a look at the rules once again, because I will be contrasting these rules with rules in 2 or 3 judgments of the Supreme Court, where the language was such that it excluded, my lords, the temporary posts. The language here in, my lords, Rule 4 of the 2004 rules which is at page 704 of your Lordship's papers. Is not a restrictive definition at all. At 705, Rule 4, and your Lordships have seen this before, district judges, 65% of the total posts in the cadre shall be filled by promotion. And the definition of cadre, your Lordships have already seen, which is Rule 8.7 of the KCSR, which is cadre means the strength of service. So read together, read plainly, there is nothing, my lords, in either of the rules which suggests, either directly or by implication, that temporary posts of the nature of these 32 would in any way or fashion be excluded. My lords have already seen Justice Anu Shivaraman's opinion, by which the appeals were allowed, follows the judgment of the Kerala High Court, my lords, in High Court of Kerala versus Mohandas. I won't read that judgment again. Your Lordships have seen it. That was a judgment that was, in our view, covering the field on both the questions that arise. One was the absence of prejudice, and the other was the interpretation, my lords, of the rules themselves, and as to why temporary posts ought not to be excluded when the rules do not so require. And that judgment, without having itself referred, my lords, to Article 233, did indeed find that the appointment really takes place at the behest of the High Court, which is, my lords, pursuant to Article 233, a complete code in itself on which there is no dispute. My lords, I had also read to your Lordships the judgment in Ganesh Rao Patnaik's case, which I will trouble the court with just once again, which is the judgment in 2005 8 SCC 454. Is it separately given? It is separately in your Lordship's case copies. This is, my lords, a matter that comes. It's a loose copy.
Yes.
Please. Para 3, your Lordships had seen, which was on the exact question of permanent versus temporary posts of additional district and session judges. Without going into that factual aspect, may I take your Lordships to Para 10, which I may be permitted to read again. Before dealing with the main issue raised in the appeal, namely the inter se seniority of direct recruits and promotees, as is the case here, the first and foremost question which requires consideration is whether, for calculating the 1/3 quota of direct recruits, as provided in Rule 6, the temporary posts of additional district and session judges have to be included or not. Rule 6 only says that of the posts in the cadre of the service, 2/3 shall be filled by promotion and 1/3 by direct recruitment. Cadre is defined in sub-rule A of Rule 2, and it means the cadre of the Bihar Superior Judicial Service. It is important to note here that the definition of cadre as given in the aforesaid rule, kindly mark this, my lords, does not say that the temporary posts have not to be taken into consideration or have to be excluded, nor is there any indication to that effect. Cadre means the entire cadre of the Bihar Superior Judicial Service, and therefore there is no warrant for excluding the temporary posts. Very respectfully, my lords, this paragraph 10 on all fours covers the question that your Lordships are now seized of in respect of these 32 posts. But I may here, in fairness, distinguish a judgment, my lords, that my friends have cited, which is the judgment, my lords, in High Court of Rajasthan versus Veena Verma. That is the judgment in 2009-14 SCC. And a key distinction, my lords, between that judgment and Ganesh Rao Patnaik is the definition, my lords, in the rules.
Now, the point also that requires to be noted is that the definition under the rule would be of significance insofar as the interpretation one by the Kerala in the Kerala case. In the Kerala case, the cadre was defined, and power was the facts make out that the power was conferred on the High Court to quantify it. Their cadre is defined to include temporary. Now, in case of Rajasthan, recruitment rules itself defines what the cadre is. Here, there is a slight, we have to fall back on the KCSR. Now, the KCSR defines cadre in a very generic fashion. And then again, no doubt the KCSR refers to permanent post, temporary post. But unlike in Kerala, where it says for 6 months or whatever, there is no certainty of how do you interpret a temporary post in our KCSR. There's slight ambiguity. Perhaps
Yes.
rules required to be tightened. One is the recruitment rules could define the cadre
Yes.
as has been done in Rajasthan. And in case it is left to the KCSR definition of cadre, there is slight ambiguity in our KCSR insofar as what temporary, permanent, etc.
My lords, if I revert to the principle laid down in Ganesh Rao Patnaik, the test for interpretation would be whether there is an exclusion or not, and not so much whether there is an express inclusion. Now, no doubt in Kerala, the rule defining cadre strength was more explicit because it used the phrase all such temporary posts existing for more than 6 months.
There is no exclusion. Tamil Nadu judgment also. Tamil Nadu Rajagopal is referring. They same.
Yes.
In Kerala, my lords, the rule defining cadre strength was, of course, more explicit because it said so in so many words that all such temporary posts existing for more than 6 months and all such posts created by the government from time to time in the Kerala State Higher Judicial Service. But notwithstanding that, the division bench in that judgment didn't confine its interpretation to the rule alone. It in fact went beyond that while observing in para 10 the generic understanding of the phrase cadre. Lordships have seen para 10. And moreover, noticed, my lords, that it was for the High Court to quantify the same, which is para 11. As I submitted, my lords, this power is not restricted by statute. It is traceable, my lords, to Article 233. So any ambiguity in a rule, assuming that is the case, would have to be addressed by taking into account, my lords, the larger constitutional framework applicable to such appointments, promotions, etc. of district judges. Now, that coupled with the principle in Ganesh Rao, as I submitted, was that there is no exclusion. I want to, my lords, also cite before your lordships two judgments which may drive this point home further. On Veena Verma, my lords, I will only say that the rules were different in that case, and therefore that by itself does not change the scenario in any way. Please see two judgments that I'm now placing for your lordships. One is, my lords, the judgment in V. Bhaskar Rao, which is 1993 3 SCC 307, which my colleague is now furnishing to your lordships. Please see how the question is, my lords, almost pari materia. Lordships have that note.
Okay, then ನೋಡಿ. Take out the book.
I'm sorry, I was told the copies were ready.
Citation once again, can you tell?
1993 3 SCC 307.
Para number?
Lords, para 1 for the facts,
Yes.
and then para 12 for the ratio. Kindly bear with us for a moment, Lords.
Book ಕೊಡಿ. SCC 93 volume 3. SCC online ಇಲ್ಲಿ ಕೂಡ ಲಾಗಿನ್ ಆಗಬಹುದು. ನೆಟ್ಕೊಳ್ಳಿಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ ಮುಂದೆ ನೀವು.
I'm so sorry for the delay, my lords. I don't know
No,
what
you can just go through it.
I'll read it to your lordships while my friend, my lords, finds the copies. Now, my lords, para 1 of this judgment, petitioners and respondents 4 to 16 are district and sessions judges in the state of Andhra Pradesh. The petitioners are direct recruits, whereas the respondents were promoted from the subordinate judiciary. The respondents were initially appointed on temporary basis in 1978-79, but they were made substantive in the year 1983. The petitioners who were appointed substantively in the year 1981, almost similar scenario, claim seniority of the respondents by way of this petition, which was filed under Article 32. I believe the copy is available now. Please, my lords. So the facts are almost pari materia. The rules in interpretation are at para 2. The recruitment of the Andhra Pradesh Higher Judicial Service is governed by rules called the AP State Higher Judicial Service Special Rules, and the rules are mentioned therein. The appointment is in Rule 2, extracted thereunder. The ratio is in the explanation. Now come to para 3, kindly, my lords. We may briefly notice the scheme of the special rules. Rule 1 constitutes the service. Category 1 consists of district and sessions judges in grade 1, and category 2 consists of district and session judges second grade. Please mark this, my lords. Rule 1 does not say that the service shall consist of only permanent posts. All the posts designated as district and sessions judges second grade under category 2 are part of the service under Rule 1. In other words, as and when a post of district and sessions judge second grade is created, permanent or temporary, it becomes part of the service under Rule 1 of the special rules. Rule 2 provides the method of appointment. I can skip that. We are not really on the method of appointment. Then, my lords, para 4. On a plain reading of the special rules, the salient features of the service can be culled out as under. Rule 1 provides for the constitution of the service. All the posts of district and sessions judges second grade created from time to time are part of the service. The natural corollary, kindly mark this, my lords, is that the service consists of permanent as well as temporary posts. Then the recruitment part, which I will skip, and take your lordships now to para 12, my lords, which is the ratio. In fact, in para 10, the question of laches was also raised, which I had raised, my lords, at the commencement of my arguments. The Honorable Court at para 11 said we see considerable force in both contentions raised. We are, however, of the view that it would be in the larger interest of the service to dispose the petition on merits. Now the merits finding. We see no force in the contention that the service consists only of permanent posts under special rules. We have already interpreted Rule 1 to mean that the service under the special rule consists of all posts, permanent and temporary, which have been designated as district and sessions judges second grade. Even otherwise, in the absence of any prohibition under the special rules, the state government can always create temporary posts as additions to the cadre. Rule 10A1 of the state rules has no application to the service which is governed by the special rules, which are the High Court rules. Rule 10A1 provides for emergency appointments made on a stopgap basis to meet a temporary exigency. Apart from that, the temporary appointments under the said rules are made without following the procedure prescribed under the rules governing the relevant service. The appointments of respondents 4 to 16, on the other hand, were made under Rule 2 of the special rules by the state government in consultation with the High Court per Article 233. We are of the view that the special rules provide a complete scheme for appointment and seniority of the members of the service. Rule 10A1 of the state rules has no application to the service constituted under the special rules. We therefore reject the contention raised. Having taken the view that the service under the special rules consists of permanent as well as temporary posts, the second contention loses its ground. Temporary posts of district and session judges second grade being part of the service, the seniority has to be counted on the basis of length of service, including the service against a temporary post. And to further support this submission, my lords, there's one other authority that I'm citing, which related, my lords, not to the judicial service per se, but to the military engineering service, but on point, which is, my lords, the judgment in A. Janardhan versus Union of India. The citation is 1983, 3 SCC 601. Here again, your lordships would find at para 6, internal page 607, two sources of recruitment: direct recruitment by competitive examination and promotion in accordance with part 3 of the rules. Now, kindly come to para 23. Now, if recruitment contrary to Rule 3 para 23. Now, if recruitment contrary to Rule 3, namely by interview of by the UPSC, which is not the recognized mode of recruitment, is held valid in Bachchan Singh, on the ground that it was done in relaxation of the rules, it must follow as a corollary that the same emergency compelled the government to recruit by promotion engineers to the post of AE in excess of the quota by exercising the power of relaxation, and such recruitment ipso facto would be valid. The promotees being validly promoted as the quota rule was relaxed would become members of the service. Whether the vacancies were in the permanent strength or the temporary cadre is irrelevant, because none of them is reverted on the ground that no more vacancy is available. Appellant and those similarly situated were recruited by promotion as provided in Rule 3.2. And it must be conceded that recruitment by promotion during these years was in excess of the quota provided in Rule 4. But the recruitment having been done for meeting the exigencies of service by relaxing the rules, including the quota rule, the promotion in excess of quota would be valid. In this connection, it may be recalled that the expression service has been defined to mean military engineering service class 1. The rules are silent, as your lordships posed the question to me, on the question of the strength of service. Keeping in view the exigencies of service and requirements of the state, temporary posts would be a temporary addition to the strength of the cadre, unless it is made clear to the contrary that the temporary posts are for a certain duration, or the appointments to temporary posts are of an ad hoc nature till such time recruitment according to rules is made. In the absence of any such provision, persons holding permanent posts and temporary posts would become the members of the service provided the recruitment to the temporary post is legal and valid, which is not in question. We are all born in the cadre. Once the recruitment is legal and valid, there is no difference between the holders of permanent posts and temporary posts insofar as it relates to all the members of the service. This clearly follows from the decision of this court in SB Patwardhan. That's the judgment in 77-3 SCC, my lords, that there is no universal rule, either that a cadre cannot consist of both permanent and temporary employees, or that it must consist of both. That is primarily a matter of rules and regulations containing the particular service in relation to which the question regarding the composition of cadre arises. 1949 rules throw no light on this aspect, and therefore if the recruitment is made from either of the sources and is otherwise legal and valid, persons recruited to temporary posts would nonetheless be members of service. Now this judgment didn't just stop at this important interpretation or ratio. It in fact went a step ahead, my lords, which was a question as to the necessity or the equity in raising such a question, my lords, when much time has passed. Your lordships have noticed the fact, my lords, that the respondents herein were originally appointed in 2015, whereas the petitioners came to be appointed in 2017. The challenge to the promotions, my lords, came to be in 2020. And it's nobody's case, my lords, that our appointments at the inception were bad, or that we had misrepresented in any manner, or there was any other inadequacy, my lords, in the process of our appointment. Now, this situation is also commented upon by the Supreme Court in this very judgment at para 38, which your lordships will also see. Before we conclude, para 38, my lords. Before we conclude this judgment, we will have a qualm of conscience if we do not draw attention to a very unjust, unfair, and inequitable situation having a demoralizing effect on public services, probably ensuing from certain rules framed by the government and the decisions of this court. Even where the recruitment to the service is from more than one source and a quota is fixed for each service, yet more often the appointing authority, to meet its exigencies of service, exceeds the quota from the easily available source of promotees, because the procedure for making recruitment from the market by direct recruitment is long, prolix, and time consuming. The government, for exigencies of service, for needs of public service, and for efficient administration, promotes persons easily available because in a hierarchical service one hopes to move upward. After the promotee is promoted, continuously renders service and is neither found wanting nor inefficient, and is discharging his duty to the satisfaction of all, a fresh recruit from the market years after promotee was inducted in the service comes and challenges all the past recruitments made before he was born in the service, and some decisions, especially the ratio in Jai Singhani as interpreted in two B.S. Gupta cases, gives him an advantage to the extent of the promotee being preceded in seniority by direct recruits who enter service long after the promotee was promoted. When the promotee was promoted and was rendering service, the direct recruit may be a schoolian or a college-going boy. He emerges from the educational institution, appears at a competitive exam, and starts challenging everything that had happened during the period when he has had nothing to do with service. A mandamus issued in Jai Singhani led to a situation where promotees of the year 62 had to yield place to direct recruits of 1966, and the position worsened thereafter. So judicial notice is taken. In the case on hand, appellant, a promotee of September 1962, is put below so-and-so, who came 14 years after the appellant, and it does not require intelligent exercise to reach a conclusion that 14 years prior, so-and-so is shown to be born on July 20th, 1950, must be aged about 12 years and may have been studying in primary school. That's on the facts of that case. shorn of all service jurisprudence jargon, let us bluntly notice the situation that a primary school student, when a promotee was member of the service, barged in and claimed and got seniority over the promotee. If this has not a demoralizing effect on service, we fail to see what other inequitable approach would be more damaging. It is therefore time to clearly initiate a proposition that a direct recruit who comes into service after the promotee was already unconditionally and without reservation promoted, and whose promotion is not shown to be invalid or illegal according to the relevant statutory or non-statutory rules, should not be permitted by any principle of seniority, kindly mark this, my lords, to score a march over a promotee, because that itself, being arbitrary, would be violative of Articles 14 and 16. Mr. So and so, learned counsel for some of the direct recruits, in this connection urged that if at the time when the promotee was recruited, his appointment by promotion was irregular or illegal, which is required to be regularized, any subsequent direct recruit coming in at a later date can seek relief and score a march over such irregular or illegal entrant. We find it difficult to subscribe to this view. Though we have dwelt at some length on this aspect, any enunciation of general principle on the lines indicated would require a reconsideration of some of the decisions of this court. We say no more, save that we have solved the riddle in this case in accordance with the decisions of this court and interpretation of the relevant rules. So, my lord, judicial notice of the inequitous situation which could emerge should, my lords, later direct appointees steal a march over promotees who have not been found in any way to have been irregularly or, my lords, invalidly appointed. And that issue, as your lordship see, was resolved by the court, keeping in mind the equities of the matter and the fact that the rules were not explicit in excluding, my lords, the temporary posts which were duly created, which your lordships have seen on these facts, borne by notification, supported by Article 233 and supported by the state before your lordships in the course of these proceedings. And this is what, my lords, at para 51 of her ladyship's judgment was one of the important factors that weighed with her ladyship while allowing the appeal, apart from the consideration of all of these legal aspects. In para 51, which is at page 96 of your lordship's compilation, the finding that it is worth mentioning that apart from stating that the promotees are in excess of the quota fixed against the cadre strength, the writ petitioners do not have a consistent case as to how many of the promotee officers are in excess of the quota as applied to the cadre strength. Further, the contention appears to be that several of the posts which are included by the High Court in the cadre strength are not posts which are permanent in nature, and that therefore those posts should not have been included in the cadre strength. The details of the posts which have been included in the cadre strength having been made available, there is further contention raised that the cadre strength should be declared separately and specifically. It is not possible to accept these contentions. Once it is accepted that posts of district judges have been created, or that posts have been created which are a matter of fact being manned by district judges, then the contention that specific notifications of cadre strength have not been effected cannot stand in the way of promotions being made to the quota as applied against cadre strength. It is only if the petitioners can specifically point out that the promoted district judges are occupying posts which are meant to be filled up by direct recruitment that they could have succeeded. This is the crux, my lords. And this, as your lordships have seen, was never even the case as such of the petitioners. It was an across the bar submission when the memo came on the record. And I have submitted, my lords, that the pleadings are bereft on this front. And this submission, my lords, that in such circumstances, roving inquiries ought not to be conducted, is the view, my lords, of the Honorable Supreme Court in one judgment. And I'm going to conclude with this and one other authority, which is, my lords, the judgment in Sadanand Helo's case. Ask your colleague to give it. That is 2008 4 SCC. Remind me. Page. This is, my lords, 2008 4 SCC, page 619. I will only read, not this was at para 58, which is at page 645. Para 58, this was again a service dispute, of course, relating, my lords, to the awarding of certain marks, etc. I'm not so much on facts as much as the principle in para 58. It is settled law that in such writ petitions, a roving inquiry on the factual aspect is not permissible. The High Court not only engaged itself into a non-permitted fact-finding exercise, but also went on to rely on findings of the amicus, or as the case may be, the scrutiny team, which in our opinion was inappropriate. While testing the fairness of the selection process, wherein thousands of candidates were involved, the High Court should have been slow in relying upon such microscopic findings. It was not for the High Court to place itself into a position of a fact-finding commission, that too more particularly at the instance of those petitioners who were unsuccessful. The High Court should therefore have restricted itself to the pleadings in the writ petition and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee, and also in process assumed the role of an appellate tribunal, which was in our opinion not proper. Thus, the High Court converted this writ petition into a PIL without any justification. So a reiteration of the necessity, my lords, to adhere to the pleadings in a case. And one division bench judgment, authored incidentally by my Lord Justice Patil, in my lords Purnima and others. This is a 2025, I believe, unreported judgment. Purnima and others versus state. Relating to, my lords, the seniority list pertaining to the deputy range forest officers cum surveyors. Kindly have a glance, my lords, only at para 13. Para 13. The applicants in application number so and so failed to specify who were the candidates actually junior to them and found place above them in the seniority list dated so and so, and how they are adversely affected by the said seniority list. Such particulars were not found in their pleadings and submissions. The tribunal ought to have rejected the application solely on the ground that the applicants have failed to point out that their juniors have been placed above them in seniority and that they were not arrayed as parties to the proceedings. It is right that the application is to be rejected in case of non-joinder who would be affected by the judgment where there is a challenge to the list. That, of course, doesn't arise here. And the end of para 15, after extracting Badami, in the instant case, the applicants have not raised a specific contention of breach of quota in their application before the tribunal, and no objections were filed to the provisional seniority list. If such plea of breach of quota rule is allowed at this stage, it would cause great prejudice to the persons in the list without making them a party to the proceedings. Now, here your lordships will see how this, in a way, leads to the can of worms being opened, because my lords would take notice of the fact that while the matter was seized off by your lordships in a reference to a full bench, a further application has come, my lords, for intervention bar impleadment by the 2018 batch. Not only, my lords, is such intervention really not contemplated at this belated stage, which is a third stage of the matter, it discloses or confirms the fact that this question, if opened, is likely to lead to, my lords, a spiraling effect, which would have the effect of, my lords, unsettling the seniority of district judges who have been appointed and been in service with due promotion in the course of their duty with no fault or misrepresentation. I can quite understand, my lords, in a given case, if it is found that there is an eligibility issue or there is some, my lords, misrepresentation or malafides of some sort, the equities turn on their head. But in these circumstances, and your lordships would kindly recall, I had begun my submission, my lords, on day one with a reference to the Supreme Court judgment, my lords, in Pankajakshi's case on the scope of the reference itself. And I won't trouble your lordships with that, except to say that the Honorable Supreme Court found that the High Court, and as in that case, the Letters Patent Act, would hold the field over the generic provisions, my lords, of the CPC or CRPC. The CRPC under Section 92 contemplates a rehearing, whereas in matters of this nature, Section 98 of CPC holds the field, unless, of course, a provision, my lords, in the High Courts Act states otherwise. And your lordships have noticed that the point of difference as such was limited, my lords, to these two factors, the fast track courts and the 32 posts, which, as I have respectfully submitted, both stand covered, my lords, by various judgments, be it of this honorable court or of the honorable Supreme Court. And really, my lords, even on any equities, there are no, my lords, special facts that would justify the original writ petitioners, my lords, in persuading your lordships to reopen this issue. And may I, in a larger, my lords, sense, respectfully submit this, that this is not, my lords, a simplicity or dispute of service rules per se. This has an effect, my lords, on the larger question of the independence and the administration of justice, because appointments and promotions of district judges are very much, my lords, in letter and spirit, covered by Article 233 and several other provisions of the Constitution relating, my lords, to the administration of justice. The state has a role, but the state has a limited role. No interpretation, my lords, which would give the state an upper hand in this scenario ought to be welcomed, is my very respectful submission, because that has a different spiraling effect of its own in time to come. The state has been fair, my lords, before your lordships, to say that what has happened is in the order of play. And therefore, I would very respectfully submit, my lords, that the view taken by her ladyship, my lords, be affirmed and the reference be answered accordingly. I'm grateful, my lords.
Yes.
Very grateful.
Yes.
Otherwise finished.
Number of judgments are cited now.
Huh?
Number of judgments are cited now.
No, but we'll restrict the scope to what we started off with.
Because I have not cited any judgment before commencing my argument, nor any enactment. Because I do not want to again remove the issue. If you permits me, I will say.
No, we'll look into it, but we don't intend to enlarge
Yes.
the scope from what we were there. We'll leave it at rest.
But none of the judgment for fact is not applicable.
We'll consider.
And Janardana is concerned what? It is referred in the Goral Memo case of Supreme Court lot. Differed with the
Close will reserve.
Now,
The records,
Yes.
High Court, my lord, which I had placed for kind perusal, maybe, my lord, leave it with your court master, my lord, or what should we do with it?
yes. Let it be with the court master. We'll return it back later.
Please.
If there's anything else within 3-4 days, anything else which you feel you have missed out, you can put it in writing and file it.
Please.
Can we do that by Monday, Miras?
Yes.
Yes, grateful.
We'll give your lordships a short written note, my lords, of our submissions.
Filing. And then give to court officer.
Can be handed over to the court officer.
Please.
Yes. Monday
Please.
morning it will be handed.
Grateful.
Grateful.
Lord, number of arguments which Mr. Bhagavat, my lord, has argued are not found in the pleading, my lord. I made that submission. Your lordships may kindly consider that also.
My lord has asked one question to additional advocate general. After 31/3/2001, is there any notification which indicates that? No answer to this statement.
Reserved for orders.
Yes.
Written submissions, if any, to be filed by Monday data.
23rd.
ಒಂದೇ ಒಂದು ಮ್ಯಾಟರ್ ತಗೊಳ್ಳೋಣ. ಕಳಿಸ್ತೀವಿ ನಿಮ್ಮ ಫೈಲ್ಗಳಿಗೆ ಒಂದು ಸಾಕು ಹೋಗಿ ಮೇಡಮ್ ತಗೊಳ್ಳಿ ರಿಸಲ್ಟ್ ಆರ್ಡರ್
ಸರ್ ರೆಡಿ ಮಾಡಿ ನೋಡಿ.
ಅದು ಯಾರು ಹೇಳಿಲ್ಲ ಜುಡಿಷಿಯಲ್ ಚೆಕಪ್ ಮಾಡುವಾಗ ಯಾರು ಹೇಳಿಲ್ಲ ಜುಡಿಷಿಯಲ್ ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ ಶ್ರೀನಿವಾಸ್ ಜುಡಿಷಿಯಲ್ ಕೇಳಿದ್ರೆ ನಾನು ಇವಾಗ ಅದು ಅಟೆಂಡ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್ ಹಲೋ ಹಾಂ ಮೇಡಮ್ ಹೇಳ್ತೀರಿ
for orders and judgment and non-work.
ನಮ್ಗೆ ಇನ್ಚಾರ್ಜ್ 6-7 ಇಲ್ಲ ಅದು ಮತ್ತೆ ಕೇಳರ್ ಎಲ್ಲರಲ್ಲಿ ನಮ್ಗೆ ಅದಕ್ಕೆ ಯಾವುದೋ ಅರ್ಜೆಂಟ್ ಅಂತ ಯಾವ ಮ್ಯಾಟ್ರ್ ಅಂತ ಯಾವುದಂತ ನನಗೆ ಬಂದು ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲ ನಾನು ಮಾಡಿಸ್ಕೊಂಡು ಅರ್ಜೆಂಟ್ ಹೇಳಿ ಯಾವುದಂದ್ರೆ ಅದು ತಗೊಂಡು ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ ಯಾವ ಮ್ಯಾಟ್ರು ಯಾವುದಾದ್ರು ಅರ್ಜೆಂಟ್ ಅಂತ ಬಂದು ಕೇಳಿದಂತೆ ಇಲ್ಲ ಅಂದ್ರೆ ಮಂಡ್ಯಗೆ ಆಗ್ತೀವಿ ಮಂಡ್ಯಗೆ ನಾವು ಹೇಳಿದ್ರೆ ಮಾಡ್ತೀವಿ ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ ಹೇಳಿದ್ರೆ ಹೇಳಿದ್ರೆ ಹೇಳಿ ಇಲ್ಲಾಂದ್ರೆ ಮಂಡ್ಯ ಫುಲ್ ಬೆಂಚ್ ನಡೀತಾ ಇತ್ತು ಫುಲ್ ಬೆಂಚ್ ರಿಸರ್ವ್ ಆಗುತ್ತೆ
Sir, WA has been reserved. Excuse me, sir. WS have been reserved, right?
ಇವ್ರದ್ದು ಅದೇನು ಅಷ್ಟು ಅಂಗಡಿ ಕೊಡ್ತಾರೆ ಕಟ್ಟಿಂಗ್ ಅಲ್ಲ ಇದು ಸತೀಶ್ ಕಟ್ಟಿಂಗ್ ನಾನೇ ಸೇರಿಸ್ಲಿ ಬಿಸ್ತೀನಿ ಕಟ್ಟು ಅಂತ ಕಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ ಸರಿ ಬಿಡು ಒಂದ್ಸರಿ ಮಾಡಿದ್ ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಸರ್ ಫುಲ್ ಬೆಂಚ್ ಆಗೋಯ್ತು ಫುಲ್ ಬೆಂಚ್ ರಿಸರ್ವ್ ಆಯ್ತು ಎಲ್ಲ ಮಾರ್ಕ್ಸ್ ತಾವು ಮಾಡ್ಕೋಬಾರ
ನೀವು ಮಾಡಿಸಿ ಸರ್ ನಾನು ತಂದಿದ್ದೀನಿ
ಮೇಡಮ್ ಇಷ್ಟು ಮಾಡಿ ಜೋಡಿಸ್ಕೊಟ್ಬಿಟ್ಟೆ ಹಂಗೇನಿದೆ ಜೋಡಿಸಿ ನೋಡ್ಬೇಕು ಎಲ್ಲ ಮೇಡಮ್ ಹೋಗ್ಬೇಕಲ್ಲ ಅದಕ್ಕೆ ರೆಡಿ ಮಾಡ್ತೀವಿ ಮುಂದೆ ಫೋನ್ ಮಾಡ್ತೀನಿ ಮತ್ತೆ ಇನ್ನು ಕೇಳಾಗಲ್ಲ ಅವರು ಅಪ್ಡೇಟ್ ಅವರು ಹೇಳ್ತಾರೆ ನಾವು ಮಾಡಕ್ಕೆ ರಿಸರ್ವ್ ಸರ್ ವಾಸುದೇವ್ ಸರ್ ನೀವು ಬಂದ ಮೇಲೆ ನಾನು ಕರೆಸ್ತೀನಿ ಅಲ್ಲ ನೀವು ಬಂದ್ಮೇಲೆ ನಾನು ಸಾಹೇಬ್ ಬರಕ್ಕೆ ಹೇಳ್ತೀನಿ ನೋಡಿ ಈಗ